afternoon, everyone. We'd like to welcome you and thank you for joining our webinar to learn more about mandatory changes for federal contractor postings. A quick note before we get started, please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns, and any other questions you have about the information being presented will be answered as soon as possible after the presentation. And without further ado, here's Ashley Kaplan, our in-house senior employment law attorney. Ashley has been practicing labor and employment law for more than 18 years. Here at G-Neal, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing poster guard services to meet our customers' diverse needs. Ashley has agreed to personally follow up with a response to any posting compliance questions you submit during the presentation. And as a special offer to our attendees today, she will also be available to provide a complimentary consultation about your specific posting compliance needs. If you're interested, please indicate that in the question box, and we will contact you to set it up. And now, here's our presenter, Ashley Kaplan.
Thank you, and welcome everyone. The goal of today's webinar is to share some important information about labor law posting obligations for federal contractors and some mandatory posting changes that you need to be aware of if you're a federal contractor. If your business has any active government contracts or receives federal funding, you have special requirements when it comes to these employee postings. So in addition to all the regular posters that all employers have to display under federal and state law, you may have up to 11 additional posters that you have to hang at each of your locations. And that's not including a few new ones that are expected to be issued in the coming months. Also, the penalties for noncompliance with these federal contractor posting requirements are severe. It could include loss or suspension of your government contracts, in addition to the regular posting fines that we're all familiar with. So this is really an important topic. So today we're going to cover what additional postings you need to know about as a government contractor, how to determine which postings apply to your business, and what the new posting requirements are for 2015, including the ones that have already taken effect. There are several new ones, and also a few more that are pending. We're also going to go over a solution by Poster Guard that will help you manage all of these postings and stay on the right side of the law when it comes to federal contractor posting compliance. First, let's start with a basic understanding of what all employers have to post, and then we'll get into the specifics that only apply to federal contractors. Today's posting compliance environment is more complex than ever. As most of you probably know, all businesses in the U.S. have to post both federal and state employee notices. And depending on what state you're in, this can add up to 21 individual postings that have to be displayed on your walls. This includes 6 mandatory posters on a federal level, and then up to 15 additional posters for state law compliance. This is the list of the federal posters. There's the EEOC posting, the Fair Labor Standards Act posting, OSHA, the EPPA posting, which stands for the Employee Polygraph Protection Act, and this one is mandatory even if you don't use lie detector tests. That's a question that I get a lot. It is mandatory for all employers. And then there's the Family and Medical Leave Act posting. And finally, the USERRA posting, which stands for the Uniformed Services Employment and Reemployment Rights Act. Then on a state level, there are additional mandatory postings that are required for every business. And like I said, depending on what state you're in, this can add up to 15 additional posters. This area of compliance on a state level is becoming more complex and difficult to manage over the years because more and more laws are being passed on a state and local level, giving employees protection and employment. And whenever, with each law that's passed, there's a potential poster update or even a new poster being issued. These state posters cover a variety of topics, things like the state minimum wage rates. Those are the most popular state posters. There are also state laws on fair employment, unemployment insurance, workers' comp. There are rules around smoking in the workplace, paid sick leave, child labor. And then there's some new areas that we're starting to see, like human trafficking, expanded family care rights, and parental leave and caregiver leave. And also, we're starting to see posters and legislation around electronic cigarettes in the workplace. Then on top of this, if you're a federal contractor, you could have up to 11 additional postings to display at each location, which we're going to go over in some detail. And then there are also city and county postings and other local contractor postings that might apply depending on where your business is and what contracts you have as well. So something that a lot of people aren't so familiar with is that there is not a one-stop shop for free government posters. While the various agencies do provide the posters, there's not a central place where you can get all the posters you need. So it actually takes quite a bit of know-how and resources to get everything you need just for basic compliance, just on a federal and state level. It's one thing if you just have one location to worry about, but for multi-site employers, there's actually, across the nation, there are more than 370 different posters that are required on a combined federal and state level, and the posters are issued by about 175 different agencies. So in any given state, just managing posting compliance in one state alone, an employer would have to go up to 9 different agencies to get the required federal and state posters, and then another 5 agencies to get the federal contractor posters. So for federal contractors, just doing the math, we're talking about obtaining up to 32 posters from up to 14 different agencies, depending on your state. And for the most part, these agencies work independently. They don't have work share agreements or sister agreements where they provide all the posters that the other agencies require. In some cases, they do try to help out. There are some states that are pretty good at this, and you can get some crossover where one agency will have posters that are governed or enforced by another agency, but it's not a complete list. There's also not crossover between state and federal. So there's just simply not a one-stop shop where you can get all the federal and all the state posters you need for full compliance. Please keep in mind as we're going through all this information that there's no need to get overwhelmed because we're also going to tell you about a solution to help you manage all of this. And it's a solution developed specifically for federal contractors to address all the extra complexities that you face when it comes to posting compliance. But first, let's take a look at another layer adding to the complexity of posting compliance, and that is keeping up with the rapid rate of change. When the government issues new or updated posters and the old ones have to be changed out or taken down and replaced immediately to maintain ongoing compliance. The mandatory labor law posting requirements change frequently, and we've actually seen the rate of change increase to an all-time high over the past few years. Our legal team here at GNEAL monitors and tracks all of the poster changes on a daily basis, and on average, we see about 150 state posting changes a year. And every time there's a posting change, the legal team reviews the underlying laws, surrounding information. We do the research to determine if it's a mandatory or a non-mandatory change. And at least half of the changes do require a mandatory update or immediate replacement of the posters. So on average, about 75 mandatory changes a year. And when it comes to the federal posters, the federal contractor posters change at a much faster pace than the regular federal posters that all employers have to display. For the standard federal posters that apply to all employers, there have been 3 mandatory updates since 2009. But for the federal contractor posters, we've had 12 mandatory posting updates during that same time period. And there are several more pending as we speak based on new laws that have already taken effect. One reason I think why we see so much more activity for federal contractors is that the President can issue executive orders to enact laws affecting federal contractors. So the process is faster and more decisive than the process for passing laws affecting private employers, where things tend to get tangled up in legislation through the House and the Senate. They get dragged out in congressional debate. With executive orders, they're swift and immediate. Another problem adding to the complexity of posting compliance is that the government agencies don't notify businesses when these posting changes occur. A lot of people think they do. Maybe they've gotten a mailing from, and it could even be from a poster company or a provider, but the government does not notify businesses of these changes. So this can be difficult because the posting requirements and the notice of changes can be buried on different agency website pages. And a lot of times the old posters remain up on an active website link even though they're non-compliant and they're no longer the correct versions. And sometimes the posting guidelines can be confusing, and there's a lot of gray areas to be interpreted. They can be buried in statutes, regulations, or even in case law. So this makes it difficult to find the posting changes, difficult to interpret whether the updates are mandatory or non-mandatory, and difficult to determine whether there are compliance deadlines for replacing the old posters with the new ones. That's also something that isn't always so obvious on the government sites. So now we're going to talk about the specific federal contractor posting requirements. And most of these are based on what type of contract you have or what kind of funding you receive. For example, what agency that you're working with. Also could depend on the amounts of the contracts or the sale or the funding and other criteria. So we're going to go through that as well for each of these. First of all, federal contractors can be in a variety of industries, and there are so many types of businesses today that might be covered by federal contractor posting requirements. In recent years, we've really seen the number of businesses grow that are covered by these federal contractor posting requirements. And that's just because of developments in the economy and new government funding initiatives that really apply to more types of businesses. It used to be something that we would talk about mainly for construction or, defense contractors, but in recent years, we've seen this expand to more and more types of businesses, everything from finance and banking, telecommunications, technology companies, educational institutions, the transportation industry, and even a lot of nonprofit organizations as well. So this is a list of the most common postings that are required for federal contractors. And we're going to go through each one and who it applies to in more detail. But as we go over them, I'm going to highlight the pending changes that are expected to affect some of these existing posters. And then I'm going to add on the other changes that you need to know about requiring, new or additional posters. So with these federal contractor posters, I get a lot of questions about where to post them, and also whether every facility in your company has to post them. So first of all, when it comes to selecting, which buildings or facilities to display them in, as a general rule, for each posting law that applies to you, the posters have to be displayed in all facilities where any work is being performed that relates to the government contract. The standards are a little bit different under, for each of the posters and under the various laws, but that's the gist of it. So if you have a facility where any work is being performed that relates to the government contract, then the posting requirements apply for that facility. And also this is kind of interpreted broadly. It can include any contract-related work whatsoever. So that can apply to, support roles like payroll, HR for, the employees who are performing the contract work, or other support functions like, IT, administration, inventory management, fulfillment, really any other area of your business that help carry out the purposes of the contract. Now, within each facility, the number of posting display sites that you're going to have depends on the logistics of the building and how accessible the posters are to your employees. We always get questions on, do I have a really big facility? How many posting display sites do we have? How many posters do we have to put up? Each posting law has its own specific language about accessibility, but the general rule, again, the gist of this one, is that you have to make sure the postings are displayed in a prominent and accessible location that is highly visible to all employees involved in the federal contract work. For the regular federal and state posters, it's similar, but they have to be posted in high traffic areas that are accessible to all employees. So depending on the layout of your facility, that could mean posting in multiple locations at the same address. But in some cases, you might be okay with just having one display area. Like if you're a smaller facility and all your employees have regular access to the posters, maybe they all use a common break room or a common entrance, then you might be covered with just one set of posters. It really, depends. In a large facility, you might need to post at the entrance as well as the employee break rooms to make sure that all the employees have access. Also, you need to be aware of applicant area posting requirements. As we're going to go over with the federal contractor posters, one of those has to be posted in an area accessible to both employees and applicants. And when it comes to the regular federal posters that all employers have to display, there are also some applicant posting requirements. In fact, 4 out of the 6 federal posters that we went over, 4 of those have to be posted in areas where applicants can view them and where employees can view them. Okay, so now we're going to go over each of the mandatory federal contractor postings, and we're going to start with one of the newer posters, which became a requirement as of January 1st, 2015, and that's the new federal contractor minimum wage posting. In February 2014, President Obama signed Executive Order 13658, and among other things, this executive order established a new minimum wage rate for federal contractor employees. The executive order requires businesses who contract with the federal government to pay covered employees, and we're going to talk about who this applies to with more detail in a minute. It requires covered employees to pay employees at least $10.10 per hour, and that was effective January 1st. And the executive order also states that every year on January 1st, the wage may be increased or adjusted as determined by the Secretary of Labor. The final rule implementing this executive order was published in October 2014 by the U.S. Department of Labor, and the final rule clarified a few things. It clarified that the minimum wage increase applies to new contracts and replacements for expiring contracts beginning on January 1st, 2015. And it also clarified what kinds of contracts are covered, meaning an employee has to do work in connection with one or more of these kinds of contracts to be covered by the new minimum wage. And there are 4 scenarios where someone would be covered as an employee. First, there are contracts for construction under the Davis-Bacon Act. And Davis-Bacon Act contracts are for work on federally financed construction projects for the actual construction, alteration, or repair of public buildings or public works. And we're going to circle back to this law in a moment because it has its own separate posting requirement as well, the Davis-Bacon Act. Second on the list, there are contracts for services under the Service Contract Act. And the Service Contract Act, or the SCA, applies to federal contracts performed in the United States where the principal purpose of the contract is to provide services through the use of service employees. And providing services is different from providing products for sale. Services involve time and effort performing a service, as opposed to furnishing an end product or a good or something tangible. The Service Contract Act covers most maintenance and repair of equipment and machinery, including aircraft systems and motor vehicles. And then some other examples are computer services, custodial, janitorial, and housekeeping services, inventory services, and also trash removal services. Third on the list, there are concession contracts. And a concessions contract is a contract where the federal government grants a vendor or contractor the right to use federal property for furnishing services. So examples of concessions contracts that are generally covered are contracts to operate souvenir shops, like in national parks or even fast food restaurants in federal buildings. It could also include contracts providing lodging, automobile fuel, newspaper stands, or recreation equipment. And it doesn't have to be services for the government. These contracts are covered whether the services benefit the government, its personnel, or even the general public. And the final category, fourth on the list, are contracts entered into with the federal government in connection with federal property or lands for services. And this really refers to leases of federal property, including space and facilities, and licenses to use such property. So these are contracts providing services on federal property, things like child care or dry cleaning, credit unions, gift shops, barber shops, coffee shops, or even fitness centers in federal buildings. And again, that's whether it's just used for federal employees or open to the public. And as part of the final regulations, there is also this mandatory posting requirement, which applies to all federal contractors that have covered employees performing work in connection with any of these types of contracts. Also, this slide shows the image of the poster, and again, it should already be up and posted. It was required as of January 1st to avoid fines and penalties for noncompliance. Okay, now we're going to talk about the NLRA poster. A lot of you probably heard over the past few years, there was a lot of buzz around this one. There was a lot of buzz around a posting requirement that was part of a rule issued by the National Labor Relations Board, and that requirement would have applied to all employers. It was a requirement that was going to force all employers to post this NLRA poster advising employees of their right to form a union. And that went through a lot of litigation, and there was a lot of debate around it. And then finally in the summer of 2013, there was a series of court cases that essentially struck down this posting requirement and invalidated it. But that requirement was by the NLRB, and it was the one that was going to apply to all employers. There's still a requirement by the Department of Labor, and it's completely separate, and it's part of Executive Order 13496, and it applies to federal contractors. And that requirement is still in place, and it requires federal contractors to post this NLRA poster. So the bottom line is federal contractors are not off the hook when it comes to this posting requirement. And this is really important to know because we've heard a lot of confusion around this. A lot of employers think that they are no longer required to post it. Some even pulled it down, but it is still required for federal contractors. Here are some more details around the actual posting requirement. The content of the poster informs employees of their rights under the National Labor Relations Act to form, join, and support a union and to bargain collectively with their employer. And by the way, these are federal rights that are guaranteed to all employees, even if you have no unions and there's not a threat of unionization in your business or industry. These are basic rights afforded to all employees. The poster has to be posted in English and any language common to a significant portion of workers if they're not fluent in English. That's the legal standard. So in other words, if you have a significant portion of Spanish-speaking employees who are not fluent in English, you would have to post this poster in both English and Spanish. And of course that's true for any other language that's common to a significant portion of your workforce who are not proficient in English. This posting is required if you have any federal contracts over $100,000. And you'll see that this posting requirement is typically written right into your contracts. So if you have contracts for more than $100,000, it's typically written in as a condition for signing the contract or receiving the funding. It's actually part of the contractual agreement that you will agree to comply with this posting requirement, and that failure to post is considered a breach of contract. This posting requirement is enforced by the U.S. Department of Labor and the OFCCP. And by the way, just a side note, this poster has a minimum size requirement. It has to be 11 by 17, so it cannot be reduced down or shrunk to a smaller size just to save on wall space. You have to preserve the size requirements. Okay, now we're going to talk about E-Verify and the E-Verify posting requirements. First of all, what is E-Verify? E-Verify is an internet-based system, and it's operated by the government, the U.S. Department of Homeland Security, and it allows employers to check an employee's eligibility at the time of hire during the I-9 process. So through its database, it runs a cross-check with the DHS records and also the Social Security Administration's records to determine if an employee is eligible to work in the United States. So the reason we're talking about the E-Verify program is that all employers who participate in E-Verify have mandatory posting obligations. So who is required to participate? E-Verify is a voluntary program for most employers, but certain employers are required to participate. So for employers with federal government contracts, E-Verify participation is mandatory, so that means the postings are also mandatory. For employers without federal contracts, or if you have locations that are not involved in the federal contractor work, your posting obligations depend on what state you're in, first of all. And this is important to understand because you might have locations that are not involved in your federal contract work, but you still have to post the E-Verify postings because of the state where you're located. So this slide has the list of states where employers currently have to participate. And just a side note here, the state laws on this are quickly evolving, so there are a lot of other states right now with pending legislation to require or even to revoke E-Verify as well. Also, I've included an asterisk here next to a few of the states, and I just wanted to explain this is because technically employers in these states are allowed to use an alternative to E-Verify. But the requirements are so similar that most employers choose to use E-Verify. It's established, it works, it's consistent if you have other locations in different states, and most companies find it's just easier to comply. So we've gone ahead and lumped these in with the other mandatory E-Verify states for that reason. Also on this list, federal agencies are required to participate, and public sector employers, which are government agency or government employers that are that operate in the states that are listed here, are also required to participate. So if you're in any of these categories, you're required to participate, and you're also required to post the mandatory E-Verify postings. In addition, if you choose to voluntarily participate in E-Verify, so if any of your locations are voluntarily participating, even though they're not in these states and they're not performing work on a federal government contract, if you're voluntarily participating, the posting requirement is still mandatory. So that's important to be aware of, and a lot of people aren't. I know it sounds counterintuitive, but it is a mandatory posting requirement even for voluntary participants. So what are the posting requirements for E-Verify participants? I keep referring to postings in the plural. There are actually two posters that are required. It's the E-Verify poster, the E-Verify participation poster, and the right to work poster. And a lot of people refer to that one as the E-Verify discrimination poster. The purpose of these postings is to notify applicants and employees of their rights under the E-Verify program. Also, as a heads up that you do run their information through E-Verify. And also, it's to let them know that they can't be discriminated against because of their national origin or citizenship status. Again, it's all based on eligibility to work and work authorization, and that is not connected to citizenship or necessarily or to national origin. So you can't discriminate against someone on those characteristics. Both of these posters have to be posted in English and Spanish, and that's true even if you have no Spanish-speaking employees. This applies to everyone. Also, the posters have to be displayed where applicants and employees can see them. So, in order to cover applicants, most companies comply by posting this one near an entrance. Next, the Walsh-Healy posting is one that applies to most federal contractors. It has to be posted if you have federal contracts for goods in excess of $10,000 or for services in excess of $2,500. And the purpose of this poster is to notify employees of the federal minimum wage rate, overtime requirements, child labor rules, and other safety and health requirements relating to the contract work. This poster is expected to have a mandatory update in the coming months to reflect the new information that we just went over regarding the minimum wage increase for contracts covered by the Service Contract Act. The poster now specifically refers to the Service Contract Act, but it doesn't have the new minimum wage yet. So this is one that we're monitoring. It hasn't been released yet, and even though the new minimum wage went into effect January 1st, that's actually something that happens a lot. A lot of times the government agencies delay in getting updated posters out, even though the information on the existing poster may be outdated. In some cases, it can be months after a new law has taken effect for the government to catch up and get the new poster out. So this is one that we're watching closely. Next, there's the ARA Whistleblower Rights poster. And this one has to be posted by federal contractors who receive any funding under the American Recovery and Reinvestment Act of 2009. The poster informs employees of their whistleblower rights. It lets them know that they cannot be retaliated against for making any kind of complaint or disclosure about fraud, waste, or abuse relating to the funds received under the Recovery Act. Okay, now let's talk about two of the more recent developments for 2015, and that includes the updated Department of Defense Fraud Hotline poster and the new Department of Defense whistleblower poster. These notices have to be posted by federal contractors who have contracts with the Department of Defense that exceed $5 million. And these poster changes were made as a result of an executive order signed by President Obama, and that was Executive Order 13627, and that was designed to help eliminate human trafficking by government contractors and subcontractors, and also to strengthen employee whistleblower rights. And the final regulations for this executive order went into effect on January 29th, 2015, and then the new posters were released in February. The Department of Defense Fraud Hotline poster was already required. It was an existing poster, but the latest revision includes updated information to help prevent human trafficking, so that was a mandatory change for February. The poster informs employees of the Department of Defense Fraud Hotline phone number, and also how to anonymously report fraud, waste, or abuse relating to any DOD funding. Examples of the type of abuse include human trafficking, bribery, leaks of classified information, and any other form of suspected fraud or abuse. The other poster is the Department of Defense whistleblower poster, and this was a brand new poster that was released, and it informs employees of their whistleblower rights relating to any kind of report they make regarding fraud or abuse. So it specifically notifies the Department of Defense contractor employees that they are protected from retaliation if they were to report any kind of wrongdoing by their employer. And both posting requirements are enforced by the U.S. Department of Defense. Next, the DHS Fraud Hotline poster is a bilingual posting in English and Spanish, and it has to be posted by federal contractors who have contracts exceeding $5 million with any funding by DHS disaster relief funds. It provides contact information for any employee to report fraud, waste, abuse, or allegations of civil liberties or civil rights abuses. Or also it covers mismanagement involving DHS programs or operations. So it's another fraud hotline poster encouraging employees to report wrongdoing and informing them that they're protected against retaliation. Okay, the notice to workers with disabilities has to be posted by federal contractors if they employ disabled employees paid at a special minimum wage approved by the Department of Labor. And this is a certificate employers can get from the DOL, and it allows you to pay what's known as a commensurate wage rate for disabled workers whose productive capacity is impaired by a physical or mental disability. It's a special program. And again, you have to have the certificate issued from the Department of Labor in order to participate and pay the commensurate wage rate. The poster itself explains the program and who qualifies. It also covers overtime rights, child labor laws, and how fringe benefits are handled. And this is another poster that's expected to change in the coming months because it also needs to be updated to accurately reflect the new minimum wage for federal contractors. Right now, it still refers to the general minimum wage under the Fair Labor Standards Act, but it hasn't caught up with the new law yet. The next two posters are primarily for federal contractors engaged in construction work. The first is the Davis-Bacon Act posting, and this one is required for federal contractors with any federally funded construction projects for $2,000 or more. And it has to be for the construction, alteration, or repair of public buildings or public works. And this poster notifies employees of prevailing wage requirements and overtime pay under the Davis-Bacon Act. And it also informs them about the penalties that their employer can face for making improper wage payments or for withholding overtime pay. And that can include, getting their contract payments held up, contract termination, or even debarment for up to 3 years. So it notifies the employees of the penalties their employers can face for these kinds of violations. The poster also refers to the general minimum wage rate under the Fair Labor Standards Act, so it's also expected to be updated soon to incorporate the new federal minimum wage that went into effect in January. Okay, this is another poster relating to construction work, and it's the Department of Transportation's Federal Highway Construction Notice. And this one has to be posted if you're working on any federally funded highway construction projects. The poster encourages employees to report any kind of fraud or abuse relating to highway construction jobs, including any false statements, false reports, or false claims about the quality, quantity, or cost of any work performed on the contract. So as far as the pending changes, we've already covered several that are on the horizon while we went over the existing posters, but there are a couple more that we wanted to highlight that would require brand new posters for federal contractors. The first one has to do with regulations expanding anti-discrimination protection for veterans. In September 2013, the OFCCP released new rules amending the affirmative action and non-discrimination obligations of federal contractors when it comes to veterans and individuals with disabilities. And these new amendments changed the definitions of protected veterans under VEVRA, which stands for the Vietnam-Era Veterans Readjustment Assistance Act. And the law is final. It went into effect. It's been in effect since March 24th, 2014. So this is an example of the government taking its time to issue the poster and update the existing ones, but they are addressing it. The OFCCP has actually issued a statement indicating that this change, these amendments will definitely result in a mandatory poster change for federal contractors, and the agency recently clarified that it is still working along with the Equal Employment Opportunity Commission to develop the poster. So at this time, it's not clear whether it's going to just be a new poster for federal contractors or a revision to the existing EEO poster that all employers have to post, since it affects the content of that poster as well. So the fact that these amendments impact two separate posters that are enforced by two different agencies is why this one is taking so long. But it is still on our radar for an upcoming change in the coming months based on the OFCCP's announcement that it is being actively worked on by both agencies. There's another executive order that was signed into law in July 2014, and the final regulations were issued in December stating that there will be another mandatory poster change for federal contractors. And this law was part of Executive Order 13672, extending workplace protections to federal contractor employees on the basis of sexual orientation and gender identity. And this one is already in effect. The final rule took effect on April 8th, 2015. Based on the new rule, there's a new poster expected for federal contractors, and this is similar, where the existing EEO poster that's required by all employers is also expected to undergo mandatory revisions because the content of that one is affected as well. So again, this one also is one where the agency has confirmed that it is still working on these updates. So this is another one that we're really keeping a close watch on. So everything that we've covered is just what's expected over the next several months. As I've mentioned, these federal contractor postings change frequently because the laws evolve so quickly as a result of executive orders and the expansion of federal funding in the recent years. So we're constantly monitoring new legislation and executive orders and adding them to this hot list for poster changes. I've just gone over the ones that I guess you could say are the hottest on the list. I mentioned earlier that there have been 12 mandatory changes to the federal contractor posting requirements since 2009. So I've gone ahead and listed them here on this slide. As you can see, we've had up to 4 mandatory changes in a single year, and 3 already this year. And just like with the regular federal and state posters, federal contractors are responsible for monitoring these posting changes on their own. The government agencies don't notify you when these changes occur. You might see, like we've talked about, you might see reference made to them in some of your contracts, but there is no official notification or broadcast or any kind of communication about these, especially when posters change. Also, as you can see, a lot of these posters on this list just popped up for the first time as new laws or executive orders have been passed, like 2 of the ones that we saw for the first time this year, the DOD Whistleblower poster and the Fed Contractor Minimum Wage poster. They were not, existing posters that were revised. They're brand new posters. So it's not just a matter of tracking the posters you already have. you also have to be aware of new laws that are bringing new posting requirements to stay on top of this. I also want to talk just really quickly about the risks of noncompliance and why it's important to make sure you have all the current postings and that all your posting display sites are complete and up to date. In the statutes for the regular federal postings, the government is authorized to fine up to $17,000 per location for posting violations. And that can be for missing posters or outdated posters. On a state level, the fines have a broad range. They typically range between $100 and $1,000 per violation. Frequently, I see them around in the range of $500 to $750. But each posting has its own fines attached to it. Like I said, they're enforced by all different agencies, and there are different laws underlying them. So the fines are really all over the place on a state level. For the federal contractor postings, the penalties are even more severe. As you probably know, most government contracts have these provisions written right into the contract, stating that if you fail to comply with the mandatory posting requirements, your contract may be terminated or suspended. And obviously, that can be a huge financial impact on your business to have government funding suspended or terminated all because of employee notice requirements. That's much more severe than just the regular fines that we see. And another real danger with posting violations is related to employee lawsuits and employee disputes. And there are a few different ways that posting compliance comes into play with employee lawsuits. The first, and probably the biggest, is when it comes to the statute of limitations. And the statute of limitations I like to call an employer's best friend from my experience defending companies in litigation, because it's the defense that allows you to have a claim stricken or dismissed because it was filed too late. So the statute of limitations, for example, for a federal discrimination claim is 300 days. It differs by state, but that's the federal statute of limitations. For a Fair Labor Standards Act case, for overtime or misclassification, the statute of limitations is 2 years. So typically, if you get a claim from a former employee or an existing employee for a violation that occurred outside of that window, outside of that time period, you can move to have that claim dismissed and avoid all the legal fees, for defending the claim, and also the potential liability for any kind of violations that were alleged in the lawsuit. But, however, if you have a posting violation, if you have a missing or outdated poster, courts have begun to publish more and more decisions saying that if an employee didn't have notice of their rights because the poster wasn't up, that the statute of limitations is extended or tolled, and you cannot use it as a defense. So we've seen cases where normally an old claim could have been dismissed, where the court allowed the plaintiff to pursue the claim, and it ended up in a six-figure judgment just because the posters were not on the wall. Another way that posting compliance comes into play with lawsuits is as evidence of bad faith. And all the different federal employment laws have different standards, different legal standards, where the concept of good faith or bad faith affects the employer's potential liability. It can either inflate or deflate the damages. Like under Title VII for discrimination claims, you can be assessed punitive damages. Under the FMLA and the FLSA, you can be assessed double damages, or what are called liquidated damages. And we've seen a lot of cases lately where the courts are looking at different factors to determine if a company acted in good faith or bad faith. Things like whether you had policies in place, how well you trained your managers and supervisors on compliance issues, how you respond to employee complaints. And now posting compliance is starting to come in more and more as a common factor that courts are looking at when they're considering these types of damages. Because of the complexity involved in keeping up with all the federal contractor posters, the rate of change, and the severity of the penalties for noncompliance that we just went over, we've developed a solution to help our customers stay on the right side of the law when it comes to federal contractor posting compliance. For years, Poster Guard has provided complete coverage for federal and state labor law compliance, and now we've added a new service specifically for federal contractors. And before I get into the details of Poster Guard's solution for federal contractors, I realize that some of you attending today's webinar may not be familiar with PostRegard or our basic federal and state coverage, so I wanted to back up and give you a brief overview of how it works, just to take a moment to explain how the PostRegard program works. So PostRegard is a comprehensive labor law posting solution by GNeil, and GNeil is the industry leader in posting compliance for more than 25 years. And when we talk about our standard PostRegard compliance protection service, we're referring to federal and state labor law compliance. The service covers all your federal and state mandatory employee postings. And these are the posters that we talked about in the beginning of the program, the ones that can add up to 21 postings depending on your state. And the way the service works is we start you out by sending all the mandatory federal and state labor law postings to each of your locations. All the posters are combined and printed in a condensed laminated format. And this is to save wall space, but also to ensure durability and to protect the posters from being ripped or torn or covered up to ensure compliance. And the posters are reduced, like I said, to save on wall space, but our priority is compliance. So our legal team is always reviewing the posters before they go to print to make sure they comply with minimum size, minimum font requirements. There are also color and layout requirements that we have to look for as well. Once you get your initial postings, we take care of everything from there. Our in-house legal team monitors the posters daily for changes, and whenever there's a mandatory update, we automatically send you the new posters at no additional charge, and that is, no matter how many changes there are throughout the year. I've been working with posting compliance for years. The most I've ever seen in 1 year is 14 in a given state. I saw 6 1 year in another state, but typically it's the range is from 2 to, I would say, 2 to 5 changes. Again, it totally depends on the state and the year. It's all over the place. If you're interested, we can give you that information if you'd like to see kind of the history of that. Just let us know. We also provide a 100% guarantee against government posting fines. And this means that if you're a PostRegard customer and you receive a government posting fine when you've properly displayed the most recent version of our posters that we sent you, we take full responsibility for the fine. Something else worth mentioning, to help further protect you against damages and lawsuits, we also provide complete record keeping. So we maintain up to 5 years of history of the records to help prove posting compliance. And this is something we support our customers with as litigation support, so that we have all the evidence and data that you need to respond to these requests if they come up in discovery and litigation or in a government investigation. So when it comes to federal contractor posting compliance, we realize it can be really complicated, especially keeping track of all the government contracts you have, their total value, and then figuring out how that corresponds with what posters that have to be displayed. So we also know that for most businesses, your active contracts can come and go, and that means your posting obligations are constantly changing too. And typically in a business, the person or the department that oversees posting compliance is not the same person who is overseeing these government contracts. So there's a lot of room for confusion and mistakes, and not syncing up what posters you need for the active contracts at a given time at each location. So we listened to our customers on this issue and recently developed an all-inclusive solution to make this as easy as possible. And this is a full-service solution, and it works just like the basic PostRegard service that I just went over. It can be added on to your basic federal and state service to cover all of the requirements for your state, so state, federal, and federal contractor. All of the poster updates and replacements are covered and sent automatically, just like I just described for PostRegard, and it's, of course, backed by our 100% compliance guarantee against posting fines. The federal contractor solution includes all of the required posters for federal contractors that we just went over. But we actually offer 2 versions. There's one for general industry and then one for construction. The construction one has the 2 additional posters. And I also want to mention, you can still get these posters individually if that's what you prefer. If you know that you only want 1 or 2 of these posters and the other ones don't comply. But most of our federal contractor customers have told us that they prefer to get all of the postings in this combined format, really for a number of reasons. First of all, it takes up a lot less wall space. Second, it costs less than combining the individual posters. And then, like I said, I think the biggest reason is that the area in the business responsible for posting compliance isn't always aware of the status of every contract for every location, whether it's active or how much it's worth at a given time. So by having all of the required posters, it's really the only way to make sure that nothing is falling through the cracks. Also, by getting all of the required posters on a replacement service, you're sure to get new posters automatically whenever a poster changes and whenever a new posting requirement comes out for federal contractors. And this is really critical due to the constant rate of change that we talked about, especially now, given that there are pending changes we already know about based on laws that have already taken effect. The federal contractor posting service is offered in all formats, just like our regular poster guard services. And this includes an electronic format for your remote workers or telecommuters. We also have an option where you can get all the postings in a binder format, and that's something that is just for locations that don't have wall space, like mobile service units, construction checkpoints, or it's also common for customers that have those kiosks in the mall that they just simply don't have walls. It's not a substitute for wall postings. The government has made that clear, but it is an alternative if you don't have walls. Also, we offer the federal contractor service in English and Spanish, and you may remember when we went over the posters, because of the NLRA language requirement, if you have a significant number of Spanish-speaking employees who are not fluent in English, you are required to post it in both languages. Otherwise, in terms of going with the bilingual option, it's really just it's an option. It's optional. But it is a best practice to post all of the posters in English and Spanish if you have locations with Spanish-speaking employees who are not proficient in English. You'll notice, looking at this image on the slide of the federal contractor posting kit, that the E-Verify poster is printed separately on a smaller panel. And that's just really for convenience, for the customer's convenience, to help you comply with that requirement that it has to be viewed by applicants. So it can be easily posted at an entrance apart from all your other employee notices. That way you don't have to post the entire employee display at all your entrances. Also, you'll notice that the E-Verify piece, the E-Verify posting, is a combination poster. So it has both of the required posters, the E-Verify and Right to Work, on the same panel, and both posters are printed in English and Spanish. Again, and that's because this one has to be posted in English and Spanish no matter what, even if you have no Spanish-speaking employees. By the way, whenever there's a poster that has to be posted in multiple languages by law, even if you have all English-speaking employees, Poster Guard always provides that poster in the required language as part of the regular English service at no additional charge. So if you purchase the regular English version of the federal contractor service, you're automatically going to get the bilingual of the E-Verify poster to make sure you're in compliance, because that's required for everyone to be in Spanish, to be Spanish and English. And that's something we do with all our federal and state posters. If a poster has to be posted in Spanish, for example, by all employers as a matter of law, even if you have no Spanish-speaking employees, we automatically include that Spanish version with our English service at no additional charge. And currently there are 22 states, and now Washington, D.C., too, that require certain postings in Spanish for all employers, again, whether you have Spanish-speaking employees or not. So this is critical to be aware of, and you really need to make sure that you have a solution that's covering all of these requirements. Before we conclude, I also wanted to highlight a new trend that we're seeing. There are actually a lot of cities and counties that are now requiring businesses to post employee notices. And this is a list of some of the bigger ones and some of the most recent ones that have cities and counties that have passed ordinances with mandatory posting requirements. And some of these cities on this slide require multiple postings per location. For example, there are several posters that are required in Philadelphia and in Seattle. And in San Francisco, I believe there are 7 mandatory postings now. So imagine that, on top of the federal and the state postings, that you had 21 plus 7, that's 28, and then if you have the federal contractor postings on top of that, that can be really burdensome. So in terms of the city and county postings, the legal team is monitoring and tracking these, and this list is quickly growing. Almost daily, we're analyzing new legislation and ordinances that are coming out and determining whether they require mandatory postings and adding them to our offering as they come out. And these posters typically cover things like minimum wage. A lot of cities have their own higher minimum wage rate. They might also have their own paid medical leave rules, and they might have different discrimination provisions. There might be different protected characteristics, for example. Like some cities recognize political affiliation or marital status as protected characteristics, even though federal law doesn't. So there can really be a lot of different laws that have to be followed and that are reflected in these city and county posters. And by the way, even though the information on the posters may conflict, this is a question I get all the time. You have conflicting information on the posters. You have a federal, state, and city poster, and they all say different things. You still have to post them all. When it comes to which law to follow, of course you have to go with the ones that are the most generous to the employees. So that would mean, in the case of minimum wage, you have to follow the highest minimum wage rate when you're paying your employees. But you still have to post all of the posters, federal, state, and city, based on your location. And any of these city or county posters can be added to your regular Postal Guard service with the full service monitoring, automatic replacements, and compliance guarantee. Okay, well that wraps it up. I hope you found this presentation to be helpful and informative. I know we went over a lot of legal requirements and details, but there's a lot to share when it comes to these laws and the complexities that federal contractors have to manage when it comes to posting compliance. If you have any questions or would like additional information about Postal Guard or any of the compliance issues that I've talked about today, please feel free to contact Manny Barrios, our compliance specialist, at 954-514-2274, or you can reach out to Manny by email at mbarrios@postalguard.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.